Hello, everyone. I hope you're having a wonderful New Year's Eve. My name is Alexander Naum, and I am a law clerk here at Lowes Parker. Welcome to today's webinar hosted by the Home Care Association of Louisiana. Today's webinar is entitled, Reading the Tea Leaves. What are the top risks your hospice or home health agency will face in 2025? Today's presenters are Robert Saltaformaggio and Matt Catoe. Robert Saltaformaggio is a senior counsel at Lowes Parker and focuses on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. He represents clients nationwide in connection with many health law matters, such as coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion or termination issues. He has worked with a broad mix of providers, including wound care specialists, home health companies, hospice agencies, substance abuse providers, mental health professionals, physical therapists, and primary, urgent, and specialty care practitioners. And then our other speaker, Matthew Catoe, is an associate at Lowes Parker and focuses on healthcare regulatory compliance matters. Matt has experience with auditing claims, the anti-kickback statute, and Stark Law allegations, and assisting clients in regulatory cybersecurity compliance. He has also assisted providers with medications and compliance documentation when on appeal. Quick reminder, if you have any questions throughout the presentation, please feel free to type them out in the chat box, and we will address as many as possible at the end of the presentation. Without further ado, I present your speakers.
Thanks, Alex. Welcome, everybody. And as Alex said, happy New Year's Eve. We appreciate your time this afternoon as everyone kind of wraps up the new year. And as we dive right into 2025, Matt and I are here to kind of give you a broad overview of the risk areas that your home health agency and hospice may face in 2025. If anyone's on the line, attended HCLA's conference in Baton Rouge in early November, this presentation is very similar to that one that myself and Robert Lyles presented to those attendees. Next slide. So before we dive in, I just wanted to give a brief little blurb from Justice Gorsuch in his new book, in which he states that criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something. And we've all heard that phrase that people commit 10 or 100 federal crimes a day. It just seems like the government, both at the federal and state levels, seem to criminalize everything, and it's almost like walking through a landmine these days, especially in the healthcare industry, with respect to all the rules and regulations and guidance that are put on providers just to make sure that you're staying within the four corners of the law. And that's why folks like Matt and myself are here to kind of guide you as best as we can. Next slide. So to begin, here's a kind of an overview of the current enforcement environment, both at the federal level and at the state level. So, at the federal level, we have a whole spectrum of Medicare contractors with all of their acronyms, from CERT contractors to the MACs, to the ZPICs, UPICs, RACs, SMRCs, and then down even with the state level, they have their own program integrity and enforcement agencies like the Medicare integrity contractors, the MICs. They have their own RACs, what we call the MFUCUs, which are the Medicaid fraud control units. And then both at the federal, state, and even if in the private payers, they all have their special investigation units, the SIUs. And this whole spectrum of whether they're agencies or contractors are out to identify fraud, waste, and abuse that may be going on. Next slide. So to kick things off, I kind of just want to give a brief overview of the federal enforcement. as the Biden administration winds down, kind of their approach was very similar to the previous Democratic administration under President Obama, in which, the Democratic administrations kind of wanted to focus on identifying individuals at all levels in an organization who might have had some semblance of liability with respect to breaking the law or engaging in any kind of criminal or civil misconduct. And this really was a change from the first Trump administration, in which the Assistant Attorney General Rod Rosenstein really wanted to focus only on those individuals who were, as the quote was, substantially involved. So that might be folks at the top, the CEOs, COs, CFOs, whereas the Obama administration and now with the Biden administration, they kind of wanted to focus on individuals at all levels who might have had some accountability. And so what, the really focus there is that, it's not just those individuals at the top of the business who might have some personal liability. It's really everyone, from the CEO down to the mailroom clerk, who might be involved, in any kind of misconduct. You can't just hide behind, the organization itself and any settlement agreement it might have with the DOJ or OIG. I think now that we're moving into a second Trump administration, we'll have to see whether it reverts back to, really focusing its attacks and its investigations on those who were substantially involved with any misconduct or fraud, or if they'll just continue on with the Biden administration's policy that Ms. Monaco had published a few years ago. Next slide. So with that said, let's go ahead and talk about risk issue number one, and that focuses on the Medicare Advantage and Medicaid managed care concerns. And the focus here is noting that CMS really wants to get out of the direct administration of healthcare, and it's working actively to move all of the Medicare beneficiaries to an accountable care plan. And as CMS announced back in 2023, it said that today CMS announced that 3 innovative accountable care initiatives will grow and provide higher quality care to more than 13.2 million people with Medicare. And it's part of their growth in achieving the agency's goal of having all people with traditional Medicare in an accountable care relationship with their healthcare provider by 2030. So what does this mean, and kind of what are the effects of this move? Next slide. Well, the concern for home health and hospice agencies is that a lot of your Medicare beneficiaries are now going to be controlled in under payment structures with what it's called a CDO. And a CDO are these care delivery organizations. And these are legal entities whose primary mission is the delivery of healthcare related products and services. And the issue that we're finding is that, if you have a patient who is a traditional Medicare patient, and all of your reimbursements come through CMS and your respective Medicare administrative contractor, if you undergo a post-payment or pre-payment audit, there's going to be certain appeal rights that are outlined in the regulations that say, okay, you undergo an audit, you have X number of days to file for redetermination. If that's unfavorable, you have X number of days to file for reconsideration up through an administrative law judge, the Medicare Appeals Council, and then ultimately to federal court. And so those guidelines and that appeals process and your appeal rights are all outlined in the regulations that anyone can just go online and look up. Well, with these CDOs, all of your appeal rights are outlined in the contracts that you have with that private payer. So, you really would then have to dive down into those contracts to determine, okay, I have a denied claim. What can I do? What are my next steps? How long do I have to appeal this? How many levels of appeal? Do I just have one? Do I have two? Is that CDO going to be the ones reviewing my appeal, or is it contracted out to another objective third party? So all of those are going to be your appeal rights are all going to be guided by the contracts that you have with that private payer organization, who is nonetheless acting as a CDO and kind of facilitating the oversight of payment for the care that you provide to this Medicare patient. Next slide. And so what do you need to do? Well, of course, you need to read your contracts or have your counsel read the contracts, because as we know, legalese is not the easiest language to read and understand. Because those contracts and the terms outlined therein is going to really guide your appeal rights and appeal timelines. So it's very important that you read all of them. And note that, each payor and each contract is going to be different. So, a contract with Blue Cross Blue Shield is going to be completely different than your contract with United or another private payer. So, that's just another hurdle that you're going to have to jump through to figure out all of these different payors and their rules and their rights. Next slide. Okay, now I'm going to turn it over to my colleague Matt, who's going to jump into a few more risk areas. Matt.
Thank you, Salt. So as Robert mentioned, the things that we're going into for 2025 really have to be framed in the light of the incoming second Trump administration. Specifically, I'll be addressing the non-compete clauses in employment contracts and independent contractor agreements, or ICAs. On April 23rd of this year, the Federal Trade Commission issued a final rule in the Federal Register that covered non-compete clauses. It's on the screen for your review, but simply put, it poses a comprehensive ban on all non-competes across board, up to and including senior executives, unless that non-compete was in place prior to the rule's implementation. For our purposes, this means that there are no new non-competes post April 23rd, 2024, or at the very least, there are none as it stands currently. On July 23rd, 2024, that was challenged in court, and a federal court in the Eastern District of Pennsylvania sided with the Federal Trade Commission in a case that challenges the agency's final rule, and the August 20th decision out of Texas openly challenged the rule. What this means is that there is now an injunction, a federal stay across the board on the non-competes that are making their way through the various circuits. These multiple lawsuits have prevented the final rule from taking effect on September 4th, 2024, as was originally intended. And again, the overarching question is, how will the incoming Trump administration impact this issue? Next slide, please. For home health and hospice agencies, you should care specifically because it may affect both current and incoming employment agreements. It can bar from a non-compete if the overarching courts err on one side of the injunction, or it can uphold the non-compete if they err on the other. So this goes back to what Salt was mentioning earlier, that independent contracts, each individual contract can vary, and it falls to the enforcing party, in this case, the home health and hospice agency attempting to enforce the non-compete, to make sure their contracts are in compliance with this injunction. And some of the questions that should be asked with regards to the non-competes are, does that individual qualify as an independent contractor? Are they a full employee with a W-2 and all the rights and privileges associated there too? Is there non-compete language in the agreement? It may not be an explicit non-compete, but it might be adjacent or near enough that a court can take a second look at it. Is there any language towards non-solicitation of clients or non-recruitment of staff that can be interpreted as a non-compete language if a court decides to be extra finicky? And so it falls to the home health and hospice agencies to review their contract language and make sure that it's, for all intents and purposes, laid out as a non-compete, but a non-solicitation agreement, and split those hairs, a task that Robert, myself, and other healthcare attorneys would be happy to assist you with. Next slide, please. So that leads us into the third risk area, which would be HIPAA privacy issues, specifically the Office of Civil Rights, the OCR, and their enforcement efforts. The current privacy rule of April 2003 has received just under a 500,000 HIPAA complaints since its inception. As of August 31st, 2024, the fines or penalties associated with settlements leaned towards, as you can see on the screen, $143,728,972. That is settlements. That is not what has gone to trial. That is someone settling out of court saying this is not worth us to litigate through. We do not want to proceed with this appeal. It is not worth it for us. OCR can also make referrals to the DOJ for criminal investigations. This is what is known as parallel proceedings, where the Office of Civil Rights can pursue a practice or agency on the civil side of the house for the above-mentioned fines and civil penalties, and the DOJ may, if they choose to undertake the investigation, open a criminal investigation on the other side of the house for the same or similar conduct. These criminal investigations from the DOJ usually involve the knowing disclosure of obtaining PHI in violation of the current rules. To date, over 2,000 referrals have been made to the DOJ on these grounds. That means that OCR is not afraid to involve the DOJ, and they could be interpreted as willing to involve the DOJ. The most frequent issues that will get on OCR or DOJ or both's radar primarily stems from impermissible uses and disclosures of protected health information. This can range from employees accessing patient records when they have no legitimate medical reason for doing so, to inadvertent disclosures to outside third parties who should not have access to that PHI but obtained it nevertheless. This falls into the second and third bullets on the screen, the lack of safeguards on the protected health information, and consequently, the lack of patient access to their protected health information. The lack of patient access to protected health information largely boils down to if a patient has proven they are who they say they are, and it is their protected health information, you cannot deny them access to their own PHI. They are entitled to their own records. They can request it at any time, and it falls to the agency not only to maintain those records in a reasonable and usable manner, but also to provide them upon request, while keeping it protected from individuals who are not open to that PHI. Next slide, please. This falls to the right to access patient records. This goes to what I was just mentioning. In November 2024, the Office of Civil Rights announced a civil monetary penalty of $100,000 against a mental health provider. This is the result of a complaint that the provider failed to provide timely access to the individual's medical records. There's no stalling, there's no gainsaying. If it is that patient's medical records, and it has been proven that they are who they say they are, whether through standard face-to-face interaction with ID or a series of clearance checks on the patient portals that you may or may not use, if the patient has proven they are who they say they are, they deserve and are owed access to their own medical records. The other side of the house is the lack of safeguards with protected health information. It cannot be free range to disclose any and all PHI to any individual who says that they are owed that access. You have to check and double check and make sure that they are either listed as the patient themselves or are otherwise authorized to view and receive the patient's medical health records. An example on screen indicates that a breach report of a Washington State hospital stated 23 security guards in the hospital's ER used their login credentials to access the patient's medical records with no job-related purpose whatsoever. The hospital later agreed to pay out just under $250,000 and implement an ongoing plan to update its policies and procedures to safeguard from this ever happening again, all of which the hospital had to front the costs for. So it can get very expensive very quickly for these HIPAA matters. And it falls to the agencies to review not only what your current safeguards are, but make sure all your staff and employees are up to date on current enforcement procedures. Next slide, please. All right, I'm going to hand this back over to Salt for the False Claims Act liability of home health and hospice agencies and their owners. Salt?
All right, thanks, Matt. So the focus here is to really note that enforcement efforts are accelerating post-COVID. And from what we've seen in FY 2023, that cases, civil cases involving fraud and false claims against the government exceeded 2.68 billion. And out of that, 1.8 billion was attributable to healthcare related cases and matters. And now I know we're already into FY 2025, and I kind of expect to get the FY 2024 information in the February timeframe. So we'll see if that trend continues, and we expect it will. What's notable about FY 2023 is that, as you can see, more than 700 whistleblower cases were filed, and more than 1,200 new False Claims Act cases were initiated in 2023. And that was the first time more than 1,000 new False Claims Act cases had been filed in a single year. Another notable point was in 2023, the DOJ and whistleblowers were party to nearly 550 settlements and judgments, which were the highest number in a single year. I think one interesting fact is there has been some legal cases surrounding whether relators, which we call the whistleblowers in a False Claims Act, whether that is legal under the Constitution. But for now, we'll just continue to move forward as if they are legal. And again, we expect that the civil fraud recoveries, the amounts will continue to increase from what the 2024 data will show. Next slide. So we've also seen an expansion of the justifications under which CMS can revoke a provider's billing privileges. The ones highlighted in blue are some ones that have been recently new. And what we see, traditionally, the number one justification for revoking a provider's billing privileges was an abuse of billing privileges, number 8 there. And oftentimes that stems from, failure to demonstrate corrective actions following successive unfavorable audits or, audits with high error rates. Any other kind of felonies are easily seen as, ways to revoke a provider's billing action. But the ones in blue are new, and I've even recently had a client who has come under the purview of one of these new revocation actions. If you'll see number 18, revocation under a different name, numerical identity, or business identity. I think this is interesting to highlight as kind of an example where our client, for a time, owned several different hospice and home health agencies, and for one of her hospice agencies, she underwent an audit, and the results of that audit were unfavorable, and she had a very high error rate. Well, fast forward a couple months, she sold one of her hospice agencies to a party who had no relationship, business or personal wise, and then come to find out, CMS revoked the billing privileges for that hospice agency simply due to the fact that my client had previously owned it. And so, and the unfortunate and sad thing is that the hospice agency that had been sold had not undergone any audits, had perfect, reports and relationships with CMS and the Medicare administrative contractor, but simply because our client previously owned it and had her billing privileges for a separate hospice agency revoked, gave grounds for CMS to then revoke the privileges of another hospice agency. And she actually had several of her entities all had their billing privileges revoked simply because one of her hospice agencies had an extreme high error rate after an audit. So we really see CMS kind of broadening broadening and expanding its reach on ways in which to revoke a provider's billing privileges. Next slide. So this slide just kind of provides some more nuanced information on some of the new ones. With respect to number 1, the non-compliance revocation ground, we see that CMS is really expanding the enrollment requirements so that there's more nuances for which to base a revocation because a provider is not meeting all of the nuanced enrollment requirements. We're also seeing that CMS has expanded, so not only criminal convictions, but now misdemeanor convictions are being used as a basis to revoke a provider's billing privileges. And, kind of just working on the one, number 5, debt being referred to the U.S. Department of Treasury if you undergo an audit and Medicare is unable to recoup any of the alleged identified overpayments, and that debt has been referred to the Treasury. CMS is using that as a basis to revoke billing privileges. So again, in some, we're just seeing CMS come out with a lot of different ways in which to revoke a provider's billing privileges. So it's really, again, I note back to my reference of walking through a landmine with regard to all these rules and regulations. Next slide. So we always like to kind of show some examples of criminal cases involving various home health and hospice agencies and owners, just to give you an idea of what some of your unfortunate peers there in Louisiana have done and what they're being caught for. And a lot of these all, generally involve kickbacks, which Matt will talk about in a little bit. So, here, when it says EDLA, that's just the Eastern District of Louisiana, just one of the 2 federal courts systems there in Louisiana. So again, we have one owner of a hospice who pled guilty for illegal kickbacks to individuals, including a couple of New Orleans area physicians. Another one where a man pled guilty for, again, more kickbacks to individuals, including 2 psychiatrists who were paid $1,500 a month for referrals, as well as soliciting approximately $331,000 in kickbacks. There at the bottom, we have a psychiatrist who was referring patients for medically unnecessary home health services in exchange for $1,500 a month. So again, that might not seem like a lot, but when you're caught for these kickbacks, the damages can be significant, and the criminal liability as far as possibly going to jail can be extensive as well. Next slide. So just some more examples. Again, paying kickbacks to either home health agencies or hospice agencies is going to be really something you got to be aware of. There in the middle example, we have the government alleging that a medical director falsely claimed the number of beneficiaries who were qualified for home health services. He was sentenced up to 96 months in prison, and the medical director was sentenced to 72 months in prison. There at the bottom, the office manager of a home health agency was assisted with paying illegal kickbacks to recruiters who were then submitting claims to Medicare, falsely stating that patients were homebound and needing medically necessary services. Next slide. So now, one case out of the Western District. Again, we have, you can see with the first example, just the extent of the restitution. The owner was ordered to pay approximately $3.6 million in restitution to the government. And that was based on, for approximately 8 years, the defendant had placed 24 patients on hospice despite the fact that they were not diagnosed with a terminal condition. In the middle example, we have the defendant ordering to pay $42 million in restitution, and he was also sentenced to 240 months in prison. And that was for billing beneficiaries at the general inpatient level of care when the documentation did not support that the patients needed that level. Again, and the government was alleging, the beneficiaries were not eligible for hospice. So again, just, again, the examples really focus on a lot of the kickbacks or, submitting claims in which the documentation does not support that either the beneficiaries qualify for hospice or home health care. Next slide. So, moving on from those examples, what we kind of want to do here is for those providers who are in the hospice care space, just kind of provide an overview on the different audits and contractors that are going about identifying and reviewing claims. So the first program is called the Special Focus Program, SFP, and that program was designed to monitor hospices identified as poor performers, based on selected quality indicators. And those who were selected for review under that program were given, additional oversight that was, intended to help them improve their statistics and improve and lower their error rates. Unfortunately, any agencies that were unable to resolve the deficiency led to their termination from participation in the Medicare program. Moving forward we have the Hospice Provisional Period of Enhanced Oversight, or PPEO audits. That program was really focused on enrolled hospice providers in Arizona, California, Nevada, and Texas. And a poor showing on those reviews can result in the revocation of a hospice's enrollment in the Medicare program. I had a client who, out of California, who underwent an audit in this PPEO program, and her Medicare billing privileges were revoked after just two reviews from the PPEO. So she went through a round one review, unfortunately had a very high error rate, went through a second round about 6 months later. Again, her error rate was significantly high. And just after those two reviews, CMS came forward and revoked her Medicare billing privileges. And there was no other audits or no other negative audit history on her books, but simply those two reviews with a high error rate led to the revocation of her billing privileges. And what we're seeing from the PPO program, the primary denial reasons, we really see these are consistent across all of the hospice audits. First, the documentation submitted does not support the beneficiary had a prognosis of 6 months or less. We're also seeing claims denied because the physician narrative statement was not present or not valid. For those physician narratives, that word narrative is key. You can't just list, the beneficiary's terminal diagnosis and other comorbid conditions. That the physician's narrative really needs to be, a paragraph indicating how the patient's, presenting conditions relate and contribute to, a terminal prognosis. We're also seeing the hospice election statements not meeting the requirements, or a lack of certification for dates billed, and then hospice continuous care hours reduced. Next slide. We also see what's called the targeted probe and educate, or TPE audits. These are serious business, folks. If you're subject to a TPE audit and you fail to, get your error rate at a sufficient level, the MAC can refer you to CMS for, possible action, including either suspension or revocation of your billing privileges. At the very least, if you don't do well on a post-payment TPE audit, you can likely be placed on prepayment review. And as anyone who's been on a prepayment review knows, that can really stymie your cash flow and can lead to second and tertiary effects on, you paying your staff and paying your practitioners. Failing on TPE audits can lead to other audits or more serious audits in which, they're not just focused probe audits, they can be extrapolated to cover more claims. And from these TPE audits, similarly, the primary denial reasons, we're seeing, hospice eligibility. The documentation is not supporting a terminal prognosis of 6 months or less. We're seeing either missing or inadequate face-to-face documentations. As those in hospice know, once you get to that third benefit period, you have to perform the face-to-face. And then we're seeing either missing or incomplete certifications or recertifications. Oftentimes, it's not so much, at least from my perspective, I'm seeing missing ones. What I see often with the certifications, or really the recertifications, is that they're not timely. Either, for some reason, the recertification is completed before the face-to-face, or it's not completed within the requisite time period. So, when the certification is invalid, well, then all the services within that subsequent benefit period are going to be, denied. Next slide. The CERT audits, or the comprehensive error rate testing, these are really focused on determining whether the MACs are doing their jobs. I would say if there's a least bad audit program, it's the CERTs. They're really trying to just, even though they're performing audits, they're trying to determine whether or not the MACs are doing their job to review post-payment claims. But that doesn't mean that you're not still going to be liable if a CERT review finds any improper payments due to the documentation not supporting all the services rendered. And again, the denial reasons are going to be consistent across the board from what we've seen in the prior audits. Next slide. SMRC audits, or the supplemental medical review contractors. Noridian was tasked to act as the SMRC, and it's often conducting reviews of the general inpatient care to determine whether proper levels of care are being billed. In many cases, the contractor has found that the beneficiary was not suffering from uncontrolled pain and did not have unmanaged symptoms. And so while we've seen kind of SMRC audits decline during 2024, we think that they're going to resume in 2025 again. And as with many of these audits, if a hospice provider does poorly following a SMRC review, it can be used as a justification for CMS to either suspend the provider's billing privileges or revoke them. Next slide. And then finally, we move on to UPIC audits, so the Uniform Program Integrity Contractors. The UPICs are tasked with detecting, deterring, and preventing waste, fraud, and abuse in Medicare and Medicaid programs. These are the audits we see the most. Each UPIC has its own kind of general jurisdiction in which it'll go out and work with the MACs to identify any waste, fraud, and abuse. Primary denial reasons, again, these are going to be consistent. Eligibility deficiencies, where we're seeing patients certified for hospice when they clearly don't meet the applicable LCD guidelines to have a terminal prognosis of 6 months or less. We're seeing either issues with the election and consent forms, whether they're not correct pursuant to the regulations or not included in the patient records. Issues with billing for higher levels of care than medically necessary, or at times billing for hospice care provided by unqualified or unlicensed clinical personnel. Next slide. Okay, that's going to wrap up my area. Matt's going to jump into the anti-kickback violations, which, again, as I note, with a lot of those examples from the criminal cases out of Louisiana, kickbacks are kind of the biggest issue we see with criminal liability with respect to hospice and home health providers. Matt?
Thank you, Salt. So as Salt mentioned, these are kind of the big guns. The anti-kickback statute is kind of the big gun behind all of the audits. Successive failures or inability to meet certain thresholds as determined on an audit-by-audit basis start getting these letters thrown around. And this is the side of the alphabet soup nobody wants to see. In its simplest form, the anti-kickback statute states it is a crime to knowingly and willfully solicit, receive, offer, or pay any remuneration to any federal program beneficiary for any services payable by the federal or state healthcare programs, purchasing, leasing, ordering, or arranging for any goods or services that may be paid in whole or in part by federal and state programs. Translated from legalese, this says if it touches the federal dollar, it cannot have a kickback statute. And it is important to note that under Section 6402F2, citation there on your screen, the scienter element, or the knowing and willful intent, is an important element of an anti-kickback statute violation. It effectively lessens the requirements needed by the government to bring a criminal case under the anti-kickback statute, because it says, quote, a person does not need to have actual knowledge of this section or specific intent to commit a violation of this section. which means there is no defense saying I did not intend to defraud or I did not intend to get a kickback is not a defense under this statute. Next slide, please. The anti-kickback statute has a variety of penalties. Most of them will be pursued in a civil arena, meaning usually money related, though it can result in jail time down the road and through a parallel proceeding, which I'll get to later. The most likely penalties are going to be fines up to $100,000 per infraction, any and all exclusion from any and all federal and state healthcare benefit programs, civil monetary penalties of up to $50,000 per violation, and that back half of that sentence refers to what's known as the treble damages provision. Assessments equal to not more than 3 times the amount of remuneration paid under the agreement. This means that if an agreement is reached with an agency that has been deemed to violate the anti-kickback statute, at the end of all of the violations, all of the fines, all of the penalties, the government can, under the anti-kickback statute, put a ×3 multiplier on the end of whatever that number is, simply because it is available to them. There's usually more that goes into it than that, but it is something that we want everyone to be aware of, as the number can get very big very quickly, especially because, to the second bullet point on the screen, most courts have adopted a very expansive reading of the knowing and willful intent. A specific example is the Greber Court, which adopted the one-purpose test. Boiled to its core, the one-purpose test says if payments were intended to induce the physician to use a violator's services, even if the payments were also intended to compensate for legitimate professional services, the anti-kickback statute can be determined to be violated, and it can be seen as a violation. Next slide, please. Now, the good news, there are safe harbors. There are, the anti-kickback statute has a very wide reach. There's a lot that can fall under the remuneration definition. And to reiterate, remuneration is not just money, just so everyone is aware. It can mean ski trips or sports tickets. We've actually seen an uptick in enforcement as it relates to the use of liquor. Any kind of liquor remuneration is very much in the crosshairs with recent enforcement efforts. But there are safe harbors. Safe harbors are voluntary affirmative defenses. What this means is that a behavior can be construed in such a way to say that ordinarily, whatever the action is, would violate the anti-kickback statute. But we are within this safe harbor. Whichever one of the safe harbors or however many are in use, they will cover the behavior, for want of a better term. While a given arrangement is not necessarily a violation of the AKS, if any of the check marks of a safe harbor have not been met, I stress again, any of the elements of a safe harbor under the anti-kickback statute have not been met, the safe harbor is ineffective. They are currently subject to change, and there are currently 11 statutory and 36 regulatory safe harbors. Next slide, please. The most likely safe harbors to utilize in a home health or compensation or hospice compensation arrangement are the two on your screen: the personal services and management contract safe harbor and the employment safe harbor. Both of them are very complex and require a thorough legal assessment that lawyers like Salt, myself, and others who are specifically educated in federal regulatory compliance can help you walk through if you want to determine whether or not you're violating the anti-kickback statute. Physician ownership of the home health or hospice agencies may be protected under the small entity investment safe harbor, but compliance is very complex. And as we are aware, physician ownership of any entity knocks in the realm of Stark Law. Doesn't necessarily mean it's a Stark Law violation, but as you can see on your screen, compliance is very complex, and we strongly urge all of our clients to consult healthcare counsel if you have anything that even considers a question. It's better to triple check on the front end and stay ahead of the risk than to risk a violation of the anti-kickback statute. Next slide, please. So this is an example of the personal services and management contracts safe harbor. As you can see on your screen, it's very complicated. We have a summary to open with, and each of those individual tick boxes must be met in its entirety for the safe harbor to apply. There's no if, there's no and, there's no but, there's no I meant to. If you fail any of the checks on this screen, this safe harbor does not apply. And you also want to make sure that while you're constructing the behavior to work within the realm of the anti-kickback statute violation, you don't run afoul of any of the other federal regulatory compliance. All of this to say, anti-kickback statute safe harbors are incredibly complex. They can get out of hand very quickly, but we would be happy to help you look over and review to stay ahead of the risk and ahead of the curve, as opposed to dealing with it when it's all on fire. Prior to the issuance of the final rule for personal services and management contracts to qualify, aggregate compensation had to be set in advance. This made it very difficult to determine hourly compensation rates and per diem business arrangements. Now only the methodology has to be changed, but all other tick boxes on the screen, must be met in order to satisfy compliance. And again, to reiterate, to the specifics line on the screen, remuneration does not include payments made by a principal to an agent as compensation for the services, so long as all of the ticks are met. I'll say it till I'm blue in the face and you're tired of hearing it. Next slide, please. This is the employment safe harbor. The bona fide employee safe harbor to the anti-kickback statute violation states that there is no violation of the statute for a payment made, quote, by an employer to an employee with a bona fide employment relationship for employment in the provision of covered health items or services. This is an affirmative defense, which means the defendants have the burden of proof. And there are multiple elements in what I just read. It has to be by an employer to an employee. There has to be a bona fide employment relationship for employment in the provision of covered items or services. The Fifth Circuit has found that the safe harbor provision adopts the definition of employee set forth in the United States Code at the citation on your screen. The Fifth Circuit further noted that where a federal statute adopts a common law definition of employee, the term incorporates the general common law of agency rather than any law of particular state. This means the federal rules of the general common law control, not any exceptions that would otherwise be relevant on a state-by-state level. It just because it's legal in Louisiana does not mean the feds acknowledge it, and that is what you have to keep in mind when looking at utilizing these anti-kickback statute violations. As we mentioned, it gets very complex very quickly. The elements are on your screen. We recommend consulting with health counsel to make sure each and every one of them are met. Next slide, please. These are the risk areas that we've noticed an uptick in enforcement as it relates to the anti-kickback statute violation. Primarily business and leasing arrangements, medical director arrangements, dine and dash, specifically lunch and other items of remuneration, are still very commonplace and can be problematic. This goes back to what I was saying earlier. No liquor, no here's season tickets to the Mets, here's anything that can be seen as an uptick in payment or item of value based on the referrals to your home health hospice agency can be seen as remuneration. There's also sham arrangements where loans, research grants, speaking fees, etc., are given to an entity from which the home health or hospice agency receives referrals, cash gifts or items of other value, and the list goes on. These are the enforcement areas, but I do want to draw attention specifically to the medical directors. Engaging or employing a medical director making referrals to your hospice or home health agency is a common area of inquiry for law enforcement. And it gets very tricky because how else is one supposed to compensate a medical director for what they do in the area? Multiple medical directors will only amplify this issue and increase government scrutiny And so we urge our clients to look very carefully at the payment scale for which medical directors are being compensated. There's been an uptick, there's been mutterings and rumors up and down the circuits as to several cases that have come to light where medical directors' payment obligations have come under scrutiny, especially the more heavily compensated medical directors. Next slide, please. The OIG specifically focuses, when looking at these medical director agreements, as fair market value. In June of 2015, the OIG issued a fraud alert titled Physician Compensation Arrangements May Result in Significant Liability. This is meant to serve as a clear warning and a red flag, both to the physicians and the organizations that employ them, specifically the example on screen. OIG alleges that compensation paid to these physicians under the medical directorship arrangements constitutes improper remuneration under the AKS for a number of reasons, including that the payments took into account the physician's volume or value of referrals, and that does not reflect fair market value. That is usually the big ticket item. If the payment scale in any way accounts for the physician's volume or value of referrals, that is not the only flag, but it is one of, if not the biggest, that will increase government scrutiny when it regards the anti-kickback statute. The OIG also alleges that some of the 12 physicians cited in this example had entered into the arrangements under which an affiliated healthcare entity paid the salaries of the physician's front office staff, which is not, again, fair market value for the services rendered. Next slide, please. Another risk issue that we urge home health and hospice agencies to look into is failure to screen for excluded individuals and entities. An exclusion is defined as a final administrative action that bars participation in one or more federal healthcare programs. This exclusion authority has been delegated to the Office of the Inspector General, specifically my former employers over at OSIG, the Office of Counsel to the Inspector General. They hold exclusion authority, and they focus primarily on patient safety and the financial integrity of the federally funded healthcare programs. The exclusion penalty is often referred to as the medical equivalent of the death penalty, because it means if you are under an exclusion, you cannot touch any of the federal healthcare programs: Medicare, Medicaid, CHIPS, TRICARE, FEHPB, BP, any of the federal healthcare programs are off limits under an exclusion. And as I'm sure everyone is aware, that accounts for a very large percentage of the current payer base of patients in America. There are two different types. Mandatory, as defined in the citation on your screen, are usually imposed as a result of convictions for program fraud, patient abuse, and certain drug-related offenses. Permissive exclusions are discretionary and can be imposed for a very broad range of conduct. As we mentioned previously, Health and Human Services has delegated this exclusion authority in its entirety to the Office of the Inspector General. Most permissive actions are based on disciplinary actions taken by state licensing boards, and approximately 70% of those boards involve nurses or nursing assistants. Physicians are involved in 9% of the permissive exclusions, whereas the actual business owners, physicians, nurses, or otherwise, are involved in 3%. It's also worth mentioning that all states have parallel exclusion authority and considerations for their individual state-related programs. Next slide, please. The OIG's primary concern in using the exclusionary penalty relates to patient safety and risk of fraud. Just under half of all exclusions are related to licensing issues, and the main reasons of these license revocations are substance abuse, fraud, professional misconduct, and patient abuse. A little over half are based on felonies related to the healthcare program itself, or specifically, again, to patient abuse, neglect, fraud, or illegal substance use. Excluded employees present serious risks to any organization. It falls to the organization to check consistently and repeatedly to make sure no employee, whether it's an intern working the front desk up to the highest paid member of your C-suite staff, if anybody on the list is an excluded employee for any reason, it can taint the entire business and it can pose a serious risk to the whole organization, no matter how trivial their position may seem. Next slide, please. These are some examples of recent enforcement actions across the states. For the sake of everyone's time, I'm not going to read every one individually, but there are, the primary example there at California is worth mentioning, as a pediatric home health company not only had to pay to resolve the allegations to the tune of $377,000, but the company, not just the physician, the company also agreed to be excluded for 20 years from all federal programs and all California-related programs. Next slide, please. And that'll take us to the end. I believe that covers just about every slide. And Alex, do we have any questions that were left in the chat?
Nope, I don't see any questions. Thank you so much to our speakers, and thank you to our attendees for joining us today. I'll be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, please feel free to reach out to our speakers. Thank you to everyone, and have a great Tuesday.